The Supreme Court has denied bail to Umar Khalid and Sharjeel Imam in the 2020 Delhi riots larger conspiracy case, while granting bail to the other five accused. Now, Umar Khalid has been in jail for 5 years, and that is where he will stay. The trial has not yet begun. Now, there are a couple of questions to ask here. How come the others got bail and he did not? Are the legal technicalities under the UAPA law, which these two men have been accused under, that changes the way bail actually functions? So we look at the legal technicalities that allows for Umar Khalid to be in jail for 5 years for a trial that has not yet begun and not receive bail either. So we have to break that down piece by piece. So this is what has happened today. The court refused bail to Umar Khalid and Sharjeel Imam and granted bail to Gulfisha Fatima, to Miran Haider, to Shifa Rahman, to Mohammad Salim Khan, and to Shabad Ahmed, and five walked free. The other two will stay in jail. Now, a quick reminder of the Delhi riots case, if you don't remember. This was February 2020. Communal violence broke out in northeast Delhi during the CAA protests. Now, the violence lasted for several days. 53 people died. 700 people were injured. The Delhi police later claimed that this was not spontaneous violence. It was part of a larger conspiracy to destabilize the country. There were 20 people who were arrested, including Umar Khalid and Sharjeel Imam, and they were arrested under the UAPA, which is our Terror Act, which is a very, very strict act, and various other sections of the IPC. Now, both of these people are scholars and activists and have been in jail now for 5 years. The Delhi police, this is the Delhi police case. They say the riots were planned and orchestrated, and Umar and Sharjeel were masterminds of that orchestration. Their speeches and their actions amount to terrorist actions under UAPA because they incited other people to go out and actually commit violence. And there was a larger conspiracy, and these two men were involved in planning, mobilizing, and strategic direction, not just local violence. And this is what the police is alleging in their case. The police has also said that it has evidence to show that they attempted to disrupt essential services, to threaten national security, and destabilize the country. And this is the reason why the police has been opposing bail. Now, first question, how come the other five got bail and these two did not? That's a key question the Supreme Court has answered, saying all of the accused do not stand on equal footing in this particular case because their involvement is of different levels. So the Supreme Court has argued that each individual should be examined differently for bail, and they can't all be taken in one bucket. According to the bench, material against Umar Khalid and Sharjeel Imam suggests, and I'm quoting here, a higher level of involvement. The court has said there are reasonable grounds to believe at this stage that their conduct may fall under terror acts defined by UAPA. Their alleged role was not episodic or local, but planning and in the leadership level. The court has also stretched that while liberty is important. Now remember, under Article 21, we all have the fundamental right to liberty. It's a fundamental right that nobody can take away from you, but under a couple of circumstances. And one of those circumstances is national security and integrity. So what the court has said is that liberty cannot be seen in isolation from national security and integrity. And it has assessed, like I said, that each individual should be looked at individually when granting bail. So it's left a window open saying both of these men can come back and apply for bail again independently, but that is about in a year's time, and I'll come back to those rules. But I want to take a minute here to sidestep to understand UAPA. UAPA is different from the rest of our sections and our laws. And so bail under UAPA is also drastically different. And that is what is applying in this particular case. Now, under UAPA, bail is much harder to get. The courts will only examine whether the prosecution's case is prima facie true and not whether the accused is guilty or not, right? So remember, the court has said at this stage, the material doesn't justify bail. So it has prima facie believes that there is a case, and that's enough to deny bail. So let me tell you what that means, right? So in UAPA, there is a section 43D5. According to this section, it says, bail shall not be granted if the court believes that the accusations are prima facie true. Now, what does prima facie mean? Prima facie means that by reading the police material, the allegations appear to be believable at the first glance. So prima facie, I'm just looking at it, seems like a strong case. That's enough in UAPA because you're dealing with terrorism and there's such a massive risk to the country. Now, prima facie does not mean that guilt has been proven, which means it's not been examined. All of the evidence has not been examined. The witnesses have not entirely been heard or cross-examined. Evidence is not in trial. So it just means that bare reading of what the police have presented, if it sounds like a believable case at first glance, that is enough for the court to deny bail. It does not examine contradictions, it does not test credibility, it does not weigh defense evidence. If the prosecution story looks plausible on paper, bail can be denied. This is the way the UAPA law has been designed, and this is what it is coming under. So the burden of proof, right? So here's this is a very interesting thing. In criminal cases, normal criminal cases, if you are accused of, say, robbery, the burden of proof falls on the prosecution. The prosecution should prove that you actually committed that robbery, and the state must show why bail should be denied. Under UAPS, the other way around, the burden shifts on the accused. The accused must now show that the case is not prima facie true. This is an extremely difficult thing for the accused to do because you don't have access to the evidence. Much of the material is either call data records, protected witnesses who you don't have access to, digital material, intelligence inputs, and the accused who's already in jail at this point cannot disapprove because they can't even see the evidence that the police are presenting to the court, because most of it is protected evidence. So it becomes a very, very difficult case. The UAPA law is designed basically to catch people who are dangerous to society and keep them in jail to prevent that danger. Is very different from the rest of our laws. So the court only looks at prosecution material, which means the judge will read the FIR, the charge sheet, the police affidavits, the annexures, and the defense can argue, but it's not really that. It's a very uphill task. The court technically asks one core question: is the material to believe that the accusation is prima facie true? The length of the incarceration, how long has this person been in jail, is not really a factor. Now, in normal cases, long jail time is could be argued as a reason for bail, because in normal cases, or in not non-UPA cases, jail is the exception and bail is the norm. But in this case, it is the other way around. So it is really hard to get bail under UAPA, like I said. Let me tell you what the defense's arguments were against the police case also. So basically, Umar Khalid, Sharjeel Imam, what were their lawyers arguing? Their lawyers were arguing that the prosecution case relies heavily on speeches, slogans, and protest speeches. The political speech, they say, even if it is provocative and controversial, it does not automatically amount to terrorism. So they're saying speech does not equal terrorism. That's their fundamental primary argument. Secondly, that there is no direct actual link between, this is Umar Khalid's case, that he was not present in Delhi when the riots broke out, and the prosecution has not shown that he was at these riot sites, or that he coordinated the violence, or that he issued any instructions. So they're saying that he's not directly, you've not established a direct link between him and the actual violence. And also, the conspiracy is alleged and not demonstrated. The charge sheet does not show when, where, how the conspiracy was concretely planned. There is no financial trail, weapons trail, command structure that has actually been proven by the police. And also, one of the things that they are challenging is that all of the prosecution's case rests on protected witnesses and statements that have not been made available for cross-examination. The digital evidence basically has not been made available either. And they are saying effectively that UAPA is being stretched beyond its purpose. UAPA is actually designed for terror outfits, for armed insurgency, organized terror, but you're using it against basically critics of the government, student activists, protest organizers, and speech-based activity. So this is what the defense has been arguing, that the case is built on speech and narrative. They have not established any sort of direct link to violence, command, and execution, and UAPA is being misused. There's been a political reaction, obviously, on this denial of bail. Opposition leaders are saying that at this point, Gurmeet Ram Rahim, accused of and convicted of 2 counts of rape and murder, has been granted parole 15 times, but in this case, bail is being denied. That's the argument. A lot of BJP leaders are celebrating, saying these are terrorists, and in order to keep our country safe, that they should be kept in jail. So these are the 2 different sides of the argument that I presented before you. What happens next? Like I told you, the Supreme Court has left one door open. The court has said that Umar Khalid and Sharjeel Imam can apply for bail again 1 year from today, or after the examination of the protected witnesses. So remember, there are witnesses, like I told you, who are protected, whose identity we don't know. They will be presented before the court. When the trial begins, they will be examined. And after that, you can apply for bail again, because that will be key evidence. Now, we don't know when the trial is going to begin, because in UAPA, there is no window when the trial has to, before which the trial has to begin. So we don't know when that will happen. So effectively, a year from today, they can reapply for bail. But it does raise this question of some constitutional issues in the law, right? How long can a pre-trial incarceration go on for? Remember, trial has not started, so evidence has not been presented. So effectively, these people have been arrested because the police believe that there is a case. The police have not been asked to prove their case, and they've just been held in jail for over 5 years. Should the courts actually balance national security and individual liberty? But in this case, when you're talking about terror laws, does national security actually trump out? And is India's bail system being applied unevenly? I think today, specifically from the news cycle, the fact that Gurmeet Ram Rahim got parole again, the fact that convicted rapists, Singer, Ram Rahim, their cases are being looked at with such leniency, does not bode well in this one particular argument. And these are not political questions. It's very easy to make these political, nationalist, right-wing, left-wing questions, but they're not. They're constitutional questions, because tomorrow a different government could be in power and they could round up anybody they think is criticizing them or is against them and throw them in jail under UAPA. They're not required to present any evidence. You just settle in jail for as long as they think is necessary. So, which is very important constitutionally, we answer these questions at this point. Now, it's also another thing I want to point out to you. When denying bail, court has not given its reasons. The Supreme Court has not said, we've read this, and this looks strong and this looks weak. Because if the Supreme Court makes those comments, it will prejudice the case when the trial actually begins against either the defense or the prosecution. So it has not made any comments as to what part of the material they found, strongest or weakest. So we don't have those details right now. Fundamentally, at the end of the day, this is what I believe. This is not a case about Umar Khalid or Sharjeel Imam, although it is a larger case about the Indian justice system, about liberty, and about whether or not guilt should be proven. So, should you be in jail only after you've been proven guilty, or is it possible to just hold you in jail indefinitely? More than 5 years is a very, very long time. I mean, life changes in 5 years. Think back to where we were in 2020. I mean, this is pre-COVID. The world is different, and these two people have spent 5 years in jail without trial. Not a shred of evidence has been presented up till now. There's been no conviction. Now, under UAPA, allegation is enough to deny bail, and the courts are not deciding guilt at this stage. So they're deciding whether or not a person can wait for the trial inside jail or outside jail. Now, supporters of the verdict are saying this is necessary to protect national security and integrity. Critics are saying the process itself is punishment at this point. Because if let's assume the police take 5 years, the prosecution takes 5 years to make its arguments and present its case before the court. This person has stayed in jail for 10 years. Just the process is punishment enough. You don't even have to actually bring those charges. So there's tension here between security and liberty, and that is normally a question that most democracies struggle with. But one thing is certain, that as a country, we need to take a closer look at how long is too long when it comes to jail for under trials who have not been proven guilty. Because other than these two men, other than UAPA, this is a problem across the country. Our jails are overcrowded by people who are waiting for trials to start or waiting for trials to complete, and they're just in jail because they've been denied bail. The questions are not about this ideology, that party, right wing, left wing. It belongs to every single citizen, because this sets precedents that can be used against any one of us. And the Supreme Court has spoken for now. But we're going to have to keep a close eye on it to decide if justice delayed is not justice denied. And if in this case, this is a way of protecting our country. And if that is true, protecting our country from what?